This presentation will cover the U.S. Constitution, the Pennsylvania State Constitution, and a typical city charter, and in this case we have selected the city of Reading, Pennsylvania. The first concept that we need to take a look at here is something known as the social contract. Under the concept of this social contract, we as citizens forego certain natural rights and empower our government to act on our behalf. We do this in order to maintain social stability and to protect the collective interests of our society. For example, rather than have a person who is a victim of a crime or an offense be responsible for the redress or the correction of that offense, we establish common rules of behavior, and we establish common forms and forums for each of us to redress our grievances with our fellow citizens. Hence, the civil and criminal courts have been developed. If we take a look at the criminal courts, under the criminal courts, we empower the state to act on our behalf. The state is the moving party, or the plaintiff party, and the state is authorized to present a case to a court and to a jury with the intent that one citizen's behavior or actions will cause him or her to become punished for the things that they have done, for example, assaulting another citizen, robbing a store, shoplifting, and that is all done under the criminal courts. Under the civil courts, your situation there will typically involve a business or a person who has a grievance against another person or against another business, and we establish the civil courts so that those parties can settle that dispute in an orderly fashion, rather than, for example, if I've contracted with the XYZ company to build 2 million widgets for me and then they fail to build them, I don't have the right to go in and burn down their factory. What I have a right to do is to take them into the civil courts and have the civil courts force them to honor their contract to build my widgets. And if they don't build my widgets, or they can no longer fulfill that contract, the civil courts have the right to basically make me whole again by either awarding me monetary damages or some other type of compensation. So the social contract becomes the underlying theory of pretty much everything we do in the public safety area, and is extremely important within law enforcement. And it's important that you understand that is out there, because that forms the basis for the state to go ahead and punish a husband who has been assaulting his wife, or punishing an offender who walks into a liquor store and decides that rather than pay for his bottle of booze, he's going to stick a gun in the store clerk's face, take the money out of the cash register, and take the bottle of booze. So the social contract is a very important concept for us. Moving on to the next slide. The first area that we'll look at here will be the federal government. Our federal government is unique in that it has 3 branches and basically 3 seats of power. In other words, the president is not all powerful. He is not able to just decree laws. He has to deal with the legislature, and the legislature has to deal with the executive, and the executive and the legislature both have to deal with the Supreme Court and with a judiciary branch that also has to deal with the executive and legislative branches. So beginning with the executive power is found in Article 2 of the Constitution. The law enforcement power resides here. This is the reason why the executive, even though it's in Article 2, is the first slide I'm presenting. our power to enforce and carry out or execute the laws resides in the executive branch. The legislature does not have enforcement power. The Supreme Court does not have enforcement power. The court can, and the various Article 3 courts that have been created by Congress, for example, can issue injunctions, they can issue court orders, but what those orders simply do is direct the executive to bring a person before the court, to bring an agency before the court, or to compel them to behave in a certain way. The executive is not under any real obligation to do anything with orders from a court. For example, the court can issue an injunction, and the executive can refuse to do something, to enforce it. The courts can issue a warrant, and the executive can refuse to enforce it. Now, if that executive refuses to enforce it or refuses to comply with an injunction or something along those lines, the court does have the power to go to the legislative branch and, through the impeachment process, have that executive removed. The courts typically run through moral authority, whereas with the executive branch, since the law enforcement and the execution of the laws and the power to do that resides there, we see that especially in the federal government, cabinet level departments are set up to do that, and that that power is there in the executive. The major cabinet level departments responsible for law enforcement are going to be Justice, now Homeland Security, Treasury, the Interior Department, and to a much lesser degree the State Department. Okay, looking at the legislative branch of the federal government, we have what they call a bicameral legislature in our national government. It's made up of two bodies. The first is the Senate, and the second is the House of Representatives. The power for the Congress lies within Article 1 of the Constitution. Article 1, Article 2, and Article 3 are in an order because the people who wrote and the framers of our Constitution wanted the legislature to be the dominant body, because the House of Representatives especially is the one that is most responsive to the people, because the members of the House of Representatives have to stand for election every 2 years. The Senate is one that is supposed to be the more deliberative of the body, and that is one of the reasons why we only elect our senators every 6 years. So if we take a look at what they do, the Senate is one of the bodies that they are responsible for making the laws. The Senate has responsibility for advice and consent on appointments and in foreign affairs. By appointments, I mean like the cabinet secretaries. Each one of those has to go through a confirmation hearing before they can assume their office. So, for example, the Secretary of Transportation had a hearing, and he was treated as a witness as he went in, and the Senate either gives a yay or a nay on the process. Other offices that require the affirmative consent of the Senate for an appointment are ambassadors, members of the courts. For example, if a man or woman is nominated to a judgeship in the district courts or the appellate courts, or a nomination is made to the U.S. Supreme Court, the Senate will hold hearings and determine the suitability of the candidate or the nominee for that office. As I had indicated, ambassadors go through this. There are every general in the Army and in the Marine Corps and the Air Force, every admiral in the Navy and in the Coast Guard have gone through the confirmation process. Their names are submitted to the Senate for advice and consent prior to those men and women being appointed to those ranks. The next thing is that the Senate, among other things, is also one of the bodies that helps establish the court system and the Article 3 courts, and I'll have more on that in the next slide. The House of Representatives is really the most important of the bodies. Not only are the laws made here, but the Constitution really empowers the House of Representatives with two key things, and one is the every bill to raise taxes must originate in the Ways and Means Committee, or that's where it's been assigned by the Congress, but it must originate in the House of Representatives. And the budget has to originate in the House of Representatives. If the House of Representatives does not pass a budget, the Senate cannot just go ahead and establish a budget and then send it on to the President of how how the government is going to spend money over the next several years. All of those laws must originate in the House of Representatives. This is an ongoing problem, and one that you, as a student, you should be aware of. We've gone approximately 1,100 days now since our current Congress and President have actually enacted a budget. What they've been doing is that because the Senate is controlled by Democrats and the presidency is controlled by Democrats and the House is controlled by Republicans, and they cannot agree on a spending plan, what they've been doing is passing a series of continuing resolutions. So the makeup of the legislature is very, very important to the day-to-day governance of our nation. And we'll now be moving on to the Article 3, which will cover the courts. The judiciary. The judiciary is contained in Article 3 of the U.S. Constitution. The U.S. Constitution establishes a Supreme Court, and that's all that it does. The article basically reads that the judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may from time to time ordain and establish. Among the courts that the Congress has seen fit to establish are the district courts. We would know those as basically the trial courts, and they are the closest ones to the people, and they're set up basically to resolve disputes that are either of a national or involve either interstate commerce or some other type of national concern. The bankruptcy courts are all run by the federal government. The tax courts, there is a tax court system set up in each of the states, but there's also one at the federal level to resolve disputes between government agencies and individuals and corporations for taxation purposes. The Congress also has established the appellate courts. For example, the Third Circuit Court of Appeals sits in Philadelphia. The Third Circuit is established by the Congress. There is no constitutional reason that the Third Circuit Court of Appeals or any other, the Ninth Circuit or any other circuit, has to exist. It's just that that's how Congress has seen fit to organize the court system. Now, the Congress also has established the military court system. There is under the Uniform Code of Military Justice, any soldier, sailor, airman, marine, or member of one of the armed forces who is charged with a offense has a right to a hearing and has a right to a hearing within the military court system. We will not be covering much to do with the military courts or talking too much about that during the course of this course, outside of just that they're established under Article 3, Section 1 of the Constitution. One of the things that had popped up a number of years ago was a statement by former Georgia representative and recently presidential candidate Newt Gingrich about limiting the jurisdiction of the Article 3 courts, and he took quite a beating in the press, but he was factually correct in what he was asserting is that Congress actually determines the jurisdiction and what matters the Article 3 courts can hear. The only court that Congress does not have the power to control what kind of cases can be heard in that forum is in the U.S. Supreme Court. For example, criminal trials will not be heard in the bankruptcy or in the tax courts. That's the responsibility of the district courts. A kidnapping offense will not be heard in bankruptcy or tax court. That responsibility lies within the district courts. Appeals, however, from the district courts, the bankruptcy courts, and the tax courts all go through the Circuit Court of Appeals, having jurisdiction by geography. So Gingrich's assertion that Congress had the right to change the jurisdiction of the courts was correct, and Congress can determine certain things that are the courts are just not able to hear. Would require a direct appeal to the U.S. Supreme Court, because that is the only constitutional court in the governing the nation. So moving on to the next slide. Okay, our next slide, I'm going to discuss this concept of federalism. Federalism, as it's practiced in the American government, is simply a system of government in which power is divided between the central authority, and in this case the national or the federal government, or Washington, D.C., and the constituent political units. For example, this can be states or provinces. The example here would be that the relationship between our state governments, for example the Commonwealth of Pennsylvania and the federal government, is one in which there's a significant division of power and a significant division of responsibility. We are unique among countries in the world where our state governments are actually what created our federal government or our national government. In many other countries around the world, the national government was the first one created, usually because somebody seized power, and then they created the provincial or the state governments as ways to one, maintain that power, and then secondly as a way to reward supporters. So our system's a little bit unique in that it was the states who created the federal government. With regard to our Congress, a couple other points should be noted. That under Article 1, where the Congress was established, for a member of the House of Representatives, as I had indicated, they serve a 2-year term. Members of that body must be a minimum of 25 years of age and a citizen of the United States for 7 years. The House of Representatives is apportioned by population. It really depends on how big your state is as to how many representatives you get. For example, Wyoming has 1 representative, where California, I believe they have 50 or 60 of them. Now, with regards to the Senate, there are 2 per state, and the minimum age for a member of that body is 30 years of age. Okay, on slide 8, one of the things that I have here, or what I have here, is Article 1, Section 7 and Section 8, which are what are called and are referred to as the enumerated powers. There are quite a few of them. I would suggest that you go through them because you should be aware of what the Congress is really allowed to do. There are a lot of things our government does that are not on this list, and then there are a couple of things on the list which it does not do. And a lot of that can really be attributed to the fact that a lot of citizens just really don't know what the government is empowered to do. So at your convenience, you should probably take a look at that, or at least have some familiarization with that before you finish your education off. Okay, Article 2, Section 1 of the Constitution defines the term of the president. He holds the term basically during good behavior for a period of 4 years, and together with the vice president, who is chosen for the same term, they are elected by the electors, which are equal to the whole number of senators and representatives from each state. We don't directly elect our president. This is one of the things, and it is really a lot of ignorance, and by that I mean people just are not versed in the concept of their Constitution, and they really didn't understand what was going on during the 2000 election, where there was so much controversy over President Bush's election and his political strategy, which was to secure the election by the number of electors, realizing that there are several states that he would have a very difficult time winning. For example, his campaign had pretty much written off California during his first run for the presidency, and they had written off large portions of the Northeast, including New York and most of the New England states, because they had done the math and they had figured out exactly how many states and what states they needed to win. And that's why Florida became the linchpin, because Florida had without the electors from Florida, Vice President Gore would have eventually become president. So just keep that in mind. We are now in an election season, and you're going to hear a lot of stupid stuff said on TV. So just be aware that we elect electors who then elect the president and the vice president. And to finish up with the courts, we should just note that the judicial power, as I had indicated, is located in the one Supreme Court and in the inferior courts that Congress may from time to time ordain and establish, which means they can also destroy those courts and create new ones to replace them, and changing the jurisdiction and the subject matters which those courts can hear. One of the things in the Constitution, it should be noted, is that to avoid the political interference of having Congress or a president just arbitrarily reduce the salary of judges, it's noted in the Constitution that during the times that those judges hold their office during good behavior, their compensation cannot be diminished during their continuance in office. The reason for that is pretty obvious. They just didn't want an attorney who had given up a lucrative law practice to take on a judgeship, which quite frequently pays less than the law practice, to see his or her income really cut to nothing because they made a decision or ruled on a case, and the Congress or the president didn't like the outcome. Think about it this way. We have the case coming up with Obamacare, which we should have an opinion on, maybe even by the time our class is over with. If the president wanted to be arbitrary about that and this clause wasn't in the Constitution, what would be to stop him and the Senate from getting together and saying, okay, well, we didn't like the decision that the Supreme Court made on Obamacare, so we're going to cut all their salaries to zero. Too bad, guys. So that's what the purpose of that that rule is in the Constitution. Okay, moving on to the Pennsylvania Constitution. If we take a look at Article 2, that establishes the legislature. This is actually the first body or the first part of the Commonwealth's government that is established. Article 1 just serves as the preamble that this is going to be the supreme law of the land and for the Commonwealth of Pennsylvania, and outlining that it's a government that is established by the people of Pennsylvania to govern themselves. You end up with a bicameral legislature in Pennsylvania also. You have a General Assembly and a Senate. And the Constitution does a lot of the same things that the federal Constitution does. It outlines, how members get elected. It outlines the length of their term. For example, as noted there in Section 3, senators are elected for a term of 4 years, and representatives are elected for a term of 2 years. So this is one of the reasons why you see, like members of the House of Representatives, and in this case, members of the, Senate or the House in Pennsylvania they seem to be running for election all the time. And it's because they basically are, because by the time they get into office, get sworn in, they've really got about maybe 9 months to a year to really get something done. And from that point forward, they're back running for re-election. And one thing about politicians, they don't want to make serious decisions during election years, because it really does tend to anger the public and puts their term at risk. Because if the public's mad at them, they may get voted out. Okay, if we move over to Article 4 of the Pennsylvania Constitution, we see that the executive is established. The executive department has several constitutional offices in it. The constitutional offices are the ones that the public directly elects the person serving in the office. So, for example, in Pennsylvania, you elect your governor, your lieutenant governor, your attorney general, the auditor general, the state treasurer, and the superintendent of public instruction. And the other officers that serve are created by the General Assembly. The term of the governor is 4 years, and he holds office from the 3rd of January, and it runs out until the 2nd of January 4 years later. In New Jersey, for example, we don't elect our lieutenant governor or attorney general. We just got an auditor general, and those persons are all appointed and serve at the pleasure of the governor. The lieutenant governor in New Jersey is also the Secretary of State, and that position also should not be underscored or taken too lightly, because it is the Secretary of State who certifies elections, and in most states is responsible for notaries and making sure that public documents and record keeping is done. It's actually a pretty powerful and a very important office. In fact, if the governor is going to resign, as has happened in New Jersey recently, when the governor resigns, he submits or she submits the resignation letter to the Secretary of State, who then submits it to the legislature. So those constitutional offices are very important, and yours in Pennsylvania, you do have quite a few offices where your governor, lieutenant governor, attorney general, etc., are directly accountable to the public for their performance in office. Okay, with your judiciary in the Commonwealth has a unified judicial system as set up by its Constitution. The courts that are established by the Constitution, by the Commonwealth's Constitution, are a state Supreme Court, the Superior Court, the Commonwealth Court, and the Courts of Common Pleas, community courts, municipal and traffic courts in the city of Philadelphia, and such other courts as may be provided by law and justices of the peace. So, for example, you actually have two appellate courts, the Superior Court and the Commonwealth Court here in Pennsylvania. In New Jersey, for example, we rather than have district courts, all of our courts are aligned by county. So, for example, an indictable criminal offense or a felony criminal offense would be handled in the Superior Court of whatever county the offense occurred in. So if it was in Camden County, it would go to Superior Court in Camden County, or if it was in Atlantic City, it would be handled in Superior Court in Atlantic County. Now, in Pennsylvania, you also elect the members of your state Supreme Court, where in New Jersey, we're under what they call a modified Missouri plan, where the governor submits a nomination to the legislature, to the state senate, and the senators exercise the advise and consent role very much like the federal judges would encounter in the federal system. And then at the end of a 7-year term of service, those members of our state's Supreme Court have to go back for a rehearing, and at that, if they get through that hurdle, at that point their appointment to the state Supreme Court becomes permanent. Your system works a little bit differently in Pennsylvania, but that's because you're under a different constitution. Your system is very acceptable, and it works for what the Commonwealth of Pennsylvania needs. Okay, moving on to municipal government. Municipal governments have a constitution. It's called a city charter or a municipal charter. Every city has one. If the city is incorporated, there is a charter there that governs what the city is allowed to do and what areas of service and levels of service can be provided by that municipality. The first charter here we're going to look at is going to be the City of Reading's charter, and as you can see in section 101, the city is established, and that charter is granted by the legislature of the Commonwealth. It's granted for the health, welfare, and to provide for the health and public safety of the citizens of that community. So we'll take a look at how the city's government is broken down, and that's all spelled out in the city's charter. Okay, so as usually occurs with these constitutional and these charters, the people who framed out the system of government in this country really wanted the legislative branch to be dominant and predominant in the manner in which we govern ourselves. And we see that with the city charters. So here in Article 2, after we've recognized the grant from the Commonwealth Legislature where Reading is now going to be able to govern itself, the first branch of government that's set up is the legislative branch. Section 201 covers the composition of the city council. There's 7 members in the city council. 6 of those members are nominated and elected by district, and 1, the president of the city council, shall be nominated and elected at large by the qualified voters of the city. This is very important because it does make the at-large member and the president of the city council somebody who has authority coming from the entire city, not just from the power brokers in the particular district where that member was elected from. It makes the president of the city council also a very strong individual and a potential competitor to the mayor, and that does serve as a check and a balance on the executive power in the city government. But again, we should note that that the legislative branch is set up first in the charter, and that's done for a reason, because it's there because these people are going to be elected at a more frequent basis than the mayor is going to be, or the executive branch appointees are going to serve. So these people end up becoming very, very important in the day-to-day setting of policy for the city government. Okay, we'll start moving on to the executive branch now. Okay, and lastly, with the city charter, we get to the executive branch. The executive branch, as indicated in section 301, is the mayor's office. The executive, administrative, and law enforcement powers of the city government shall be vested in the mayor, and they reside with the mayor. This is where the administrator gets his or her authority to carry out the day-to-day functions of the city government. It's also where the police chief and the police officers get their authority to actually enforce the laws. Without having this section in the city charter, the police force can't really exist, because without having the executive there is nobody to enforce the laws. The other thing that the charter does is that it spells out the election of the mayor shall be in a manner provided by law, and that the term of the mayor shall be for 4 years. It has the term commences on the first Monday in January after his election, so we know he'll be there until, the Sunday before the first Monday, for that 4-year term. What's also important here is that the eligibility for the office is spelled out. The candidate for mayor has to be a registered voter in the city of Reading. He has to have resided in the city continuously for at least 1 year immediately preceding the primary election in which he seeks office. And he has to continue to reside in the city throughout his term of office. These are the qualifications as set down by the legislature, and the mayor has to observe those. If he doesn't, he basically forfeits his office. As an example with this, we just saw in the last several days where Senator Lugar from Indiana recently lost his primary election, and one of the big knocks on him in Indiana was that he no longer resided there. He did not maintain a residence there. He did not maintain a driver's license with the state of Indiana, and really had no contact with the state outside of serving as the state's senator in the U.S. Congress. That would not be allowed here under the city charter in Reading. The mayor must comply with this, or for example, if the mayor moves out of Reading, even if he's one house over the city line, he's still out, and he can be removed and should be removed, and is constitutionally, or according to the charter, ineligible to hold the office. And at that point, a special election or an appointment would be required for somebody to handle the executive power in the city government. So these charters and constitutions are extremely important documents. Just in summary, what they do is that they are the agreement by which you and I govern ourselves. And if we don't expect these people who are serving in these offices to abide by them, a lot of times they won't. And if they are not expected to